Hello, everyone. Happy Friday. Thanks for joining us for session 2 of our TIRSA update series. October 1st is the date when these updates come into effect, and it's very important that you're up to speed with everything. And thanks again for Madam President, Catherine Stigley-Canino, for her efforts, and Vincent Danzi for all the work they've put into these 2 sessions. And then we have our Q&A next week. So if you want to ask any questions today, we'll be happy to get them answered for you. If you want to save them up for our Q&A dedicated session next week, totally cool. If you didn't see the email yesterday, we do have a recording of last week's session if you'd like to watch it. I still need to put some timestamps in there, but that is live. Send us an email if you'd like to receive that link to the video. Today's session is updates, replacements, and additions to the endorsement forms library. That's all I got, Catherine. Your turn. Take it away. I'm gonna hide my screen.
Okay, thank you, Drew. Good morning. We will be going over endorsements today. This is a huge undertaking by New York to kind of catch up with the rest of the country on what they issue for endorsements. There have been a couple of changes, a couple of deletions, and a couple of series of new endorsements that New York has never had, but has been seen around the country. We put this as a standalone as opposed to last week when we had the manuals and forms, just because it's just a huge topic. And this is where most of what you're going to be doing comes in. So we're going to start with a couple of highlights. There are removal of 6 current endorsements with no replacements. There's a replacement of 14 current TIRSA endorsements with 25 new to us ALTA endorsements, ALTA being the forms police of the policies. They have their own set of forms. TIRSA has always adopted a New York set of forms. So what we've done is started to, in some cases, adopt the national forms. The addition of another 24 new ALTA and TIRSA endorsements, and a rewriting of 13 current TIRSA endorsements. The junior loan policy, which no one really uses, is being eliminated. The TOPE market value rider has been eliminated. The policy authentication endorsement has been eliminated and incorporated into the policy jackets. You'll see that information that in the jackets, as we explained last week, they've updated it to modern times to have a lot of electronic provisions in it. There is no more free-form affirmative insurance. As I mentioned last week, this is my favorite new change. Everything has to be done by endorsement, and that's why we're concentrating so hard on this presentation today. And most of the affirmative and coverage that we are used to giving will be in the 9 series, the 28 series, and 35 series, which we will go over in more detail as we go through this presentation. It's a huge undertaking. You know, we know everyone's going to be overwhelmed, but we're just going to take it one day at a time, and we'll be here to explain everything and to help you through until we all get used to it. These are the deleted endorsements. These have had no successor endorsements. The TIRSA Fannie Mae Balloon Mortgage Endorsement, the TIRSA Industrial Development Agency Endorsement, Junior Loan Policy Endorsements, since we have eliminated the Junior Loan Policy, the Market Value Policy Rider for the TOPE, which I had mentioned, Policy Authentication, which I had mentioned, Land Sameness Survey has been split into 2, and the leasehold endorsements that were TIRSA versions are now ALTA versions. The TIRSA Market Value Policy Rider Endorsement, which provided an adjustment for the policy to match an increase in the market value for the TOPE, has been withdrawn. It was not particularly needed because of the provisions it had within it itself. And we will go now on to replaced endorsements. Here's a chart of endorsements that have been replaced. There's a co-insurance endorsement that was a TIRSA that has been replaced by Alta versions, a co-insurance endorsement, and a co-insurance multiple policies endorsement. Those are for very huge deals where there are several title companies that are insuring the deal. You know, we may have a piece, Stewart may have a piece, Fidelity may have a piece. That's what the co-insurance endorsement covers. Contiguity endorsement, we'll go into that later on. It's been split from one endorsement to 3 separate endorsements depending on the situation, just making it a little more specific. And the first loss endorsement has been replaced by a first loss multiple parcel transactions endorsement. The land same as survey has been split into 2. Other states have had, this was a TIRSA version as well. Other states have had the same as a portion of the survey. That's when you have something like 5 row houses and you're only insuring 1. You have to say that the property is the same as a portion of the survey, and same as survey when there's 1 parcel, 1 survey. The TIRSA leasehold has been replaced by the Alta leasehold. The option endorsement, if you see, these are all TIRSA versions, and they've been replaced by the Alta versions. Some more replaced endorsements, variable rate, and the fixed conversion rate have been replaced by the Alta variable rate. Clustering endorsement has been replaced by the Alta aggregation endorsements, which we will go over later. And the TIRSA restrictions encroachments, which you know is the TIRSA 9, has been split into an entire series of Alta 9 endorsements, which Vince will explain later. And each of them is specific to a subject. Instead of having an overall comprehensive TIRSA or Alta 9, we now have specific endorsements that can be used in conjunction with each other, depending on the situation, but broken down into these subjects. There are 24 new endorsements that have never been in New York. There's a whole energy series, there's a whole encroachment series, there's a whole mineral series, there's mezzanine financing, there's tribal waivers and consent, usury, zoning, tax credit, and identified risk. These are all new to New York, and we will go over all of these. The left-hand side of your screen is mostly what we're going to be using. Replacing what we usually give for affirmative insurance, but as we go along, we'll have a lot of explanation on these. And there are 16 substantive TIRSA endorsement revisions. These mean that these endorsements were substantively changed. It wasn't just a comma or a reference to something in the main policy. These had significant clauses or phrases added. A lot of these had a lot of definitions added, and because the rate manual, as we explained last week, added a lot of definitions, so now they're just dispersed throughout all these endorsements to make for a more cohesive overall plan of insurance. Common changes to all the Alta endorsements. In general, all the TIRSA endorsements received some common updates. They were all retitled to add the acronym of the Rating Bureau to the beginning of the title, TIRSA. The word policy was replaced throughout with company. Instead of the policy hereby insures, it says the company insures. The word land was capitalized whenever used in the endorsements to more explicitly reference the land identified in the policy. Capitalized date and started using amount of insurance instead of face amount. These were all qualified terms that they made so that they would have consistency. The bottom language, which actually attaches the endorsement to the policy, was revised to the latest Alta promulgated language. We now go to the general endorsement. We explained this section last week. The general endorsement is usually only used to add recording information, change a clause, change an error, amend something that wasn't in the original policy. It's expanded to now have 2 more clauses for the general endorsement. As you see there, it says the company may issue a general endorsement without charge for the following purposes only: to amend or correct a previously issued policy, which was what we've been doing, because once a policy is issued, you can't change it except by general endorsement. To provide specific coverage for party walls. Party walls is kind of a standard little item that really didn't fit into the rest of these endorsements, so they carved out an area so that we could put the affirmative insurance that a lender may want into the general endorsement. There's very specific language. There has to be a survey, and all blanks have to be filled in with that survey information. If you look at the corresponding rate manual section on the general endorsement, it will give you the exact language for this. But this is all you can give. We're being very tight with affirmative insurance now. There's not going to be anything free form. Everything has to be exactly as it is in the rate manual. The second alternate option is for options. The general endorsement can provide specific affirmative coverage regarding the exercise of specific rights of first refusal or options for owners and loans policies. So as I see, not to be used as catch-all for other types of affirmative insurance. You can't say, well, you know what, I can't find the endorsement I need. This bank needs this right away. Let me just shove some affirmative language in the general endorsement that I know I've used before. No, cannot happen. The general endorsement can be used only for these 3 purposes. You cannot just put whatever you want in this general endorsement. You have to find what you used to give in an endorsement, and if it's a chargeable endorsement, you will charge for that affirmative insurance. There's no free affirmative insurance, and there's no free form affirmative insurance. The same with the TIRSA identified risk endorsement. This is, again, not something you can just say, oh, you know, I'm just going to put exception number 5, my CNRs into this identified risk endorsement, and that will be good enough. No, this endorsement is used to specify a covered risk not found within any other policy, jacket, or endorsement. Yes, you must specifically identify the defect, restriction, or encumbrance to be covered. You will say in your identified risk, this is the risk, this is the exception. You're very specific as to whatever it is you're insuring. The endorsement insures against loss or damage sustained by reason of final order or decree enforcing the identified risk. You'll see that whenever I change your affirmative language, I always put in the enforced removal. This means there's a final order from a court that says, yes, you must remove this. And the release of prospective purchaser, lessee, or lender from the obligation to purchase, lease, or lend if there's a contractual condition to deliver marketable title, provided that a title company is not willing to insure over same. So this is a very cautious, limited endorsement, and you must have underwriter approval. You cannot just use, oh, I'm going to throw my typical language in here, or the general endorsement. You need underwriter approval to say, they want affirmative insurance on this particular exception or this particular matter, and we have to examine it and determine whether you can issue this endorsement. Again, it's not a catch-all. It has to be something that's outside the purview of the rest of the endorsements, but strong enough to be something that we can insure against safely. I'm going to turn it over to Vincent to explain the Alta 9 series. This is going to be a popular one because it does a lot with covenants or restrictions, and some of them can be used for owners policies, but I'm going to let Vince get into that now.
Great, thank you, Catherine. So yeah, first of all, I got to meet some of you, I'm sure, during the convention. And for those that attended the recent New York State Land Title Convention, you know that they had 2 CLE 2 seminars on this same subject at the convention. And just one thing I think I would like to mention and reiterate that was said there is to understand that, you know, this is going to be new to everybody. It's going to take a little time to get up to speed on these subjects, but, you know, we'll get through it and we will learn them. We'll become more familiar with them. One thing I think it's important to understand, and Catherine has touched on this a couple times, is the whole notion of underwriter approval. We're going to have to deal with a situation now where you're going to need to get approval on a number of endorsements. Now, many of these endorsements might not be issued on every transaction, but you will find that we'll be slightly altering our procedures to accommodate the fact that we're going to have to be approving some of these endorsements more often than we would otherwise have. Another thing I want to mention before getting into the specifics of the Alta 9 and the series that came from it is that another thing to keep in mind is that although TIRSA chose to do this form implementation at the same time that they rolled out the 2021 forms, I think it's really important to understand that almost all the Alta endorsements that they did adopt are actually 2006 versions, which sort of explains some of the changes that they made to some of them. But that's another thing to keep in mind when you look at underwriting guidance about these endorsements. Understand that in many cases there is a 2021 version of them and there's a 2006 version of them. So make sure you're looking at the appropriate guidelines. Now, Catherine has also mentioned affirmative insurance, and that's really actually a very good lead-in to our little talk about the Alta 9. The Alta 9 was really created to afford a whole bunch of different affirmative insurances and became known as the comprehensive endorsement. You know, of the newly filed endorsements, let me just share my screen now with you. Bear with me, please, because let's see if I got it here. I love my multiple monitors, but it does make for a little bit more complicated thing. Now, you should all be seeing a slide that says Alta 9 series endorsements up there. Hopefully that's working. So, so in the form filing letter that TIRSA sent off to DFS, you know, it mentions that TIRSA was filing 24 new endorsements and replacing 14 current endorsements with 25 new ones. However, as we'll see right now, I think it's fair to say that one particular endorsement was actually replaced by 24 endorsements to a greater or less extent, and I'm talking about the TIRSA 9. One could say that the current TIRSA 9, which is a modified version of the American Land Title Association's Alta 9 from a couple form generations back in time, and which is itself a derived form from a form developed by the California Land Title Association, the CLTA 100, is being withdrawn and replaced by 9 Alta 9 endorsements, 3 Alta 28 endorsements, actually 4 Alta 28 endorsements, 4 Alta 35 endorsements, and 9 Alta 36 endorsements. Now, the one endorsement that comes closest to the current TIRSA 9 is the Alta 9.7, Restrictions, Encroachments, Minerals, Land Under Development Loan Policy Endorsement. It is basically, the 9.7 is basically a Alta 9, but it also provides for future improvements. As I said, the Alta 9 is the successor to the CLTA comprehensive endorsement. The endorsements, particularly the Alta 9.7 that I'm talking about right now, provide the lender with affirmative coverage regarding restrictions, covenants, easements, and surface damage resulting from the exercise of mineral rights. The endorsement does not preclude the use of other types of affirmative insurance, as long as the coverage afforded by the endorsement is not duplicated. The Alta 9 series started as a loan policy only endorsement and covered those three distinct areas of restrictions, encroachments, and minerals. And it was in these earlier days that it earned its now somewhat inaccurate name of the comprehensive endorsements. And in the years since, the Alta 9 has developed more limited versions, which now make calling it the comprehensive pretty much misleading. Now, two important things happened at about the same time from 2009 to 2012. The first was a case called the Nationwide case, where a landlord, let me just make sure I'm in the right place. Yes, move to the next slide. Yeah. The Nationwide case was a case where a landlord sued Commonwealth under their Alta 9 endorsement because they had lost a potentially lucrative new tenant for their anchor store building. What was happening was that a drugstore was leaving the shopping plaza and a technical school wanted to rent that space, but there was a covenant in the land that precluded that use, believe it or not. It allowed a drugstore but did not allow a technical school. And the Alta 9 provided that, it provides these affirmative insurances, except if it's named in an exception. And what the Nationwide case was about was that even though they had named the covenant that had the restriction that precluded the use of the property as a trade school, sorry, a technical school, because it didn't name the specific consequence of that covenant, it wasn't good enough to take it out of coverage. And so it resulted in interpretations that called for revisions to the Alta 9. And the upshot was that the Nationwide case stood for the fact that you could actually read the present Alta 9 on its own, independent of the title policy. So even if you had an exception in there, the Alta 9 kind of had its own insurance. And so that merely taking an exception containing an CNR would not be sufficient to disclaim liability. So the specific matter itself must be accepted, and this presented challenges. And that's when you started seeing these other forms of Alta 9s started growing. The Alta 9 is pretty long. It has 5 paragraphs. The first paragraph makes it plain that the endorsement is indeed subject to the terms of the policy and not to be interpreted independently. The second paragraph provides the definitions of covenants and improvements. And significantly for the loan policy, the term improvement includes lawn, shrubbery, and trees. More on that in a bit. Depending on the context, issuing a 9 series of endorsements can possibly call for extensive review of CNRs and surveys. Now, in order to accommodate situations where all 3 types of coverage are not appropriate, Alta created new sub-series inside the Alta 9 and created the Alta 28, the 35, and the 36 series. Now, let me see what I can talk about here. So what you're seeing right here, this is the current Alta 9 family as adopted by TIRSA as of October 1st. There are a couple missing. Most notably, Alta 9 itself is missing. But like I said, the Alta 9.7 is pretty darn close to it. Now you also see that there's a sub-series for conditions, covenants, and restrictions. That's basically the Alta 9 with the minerals interest taken out. And then you also have the private rights sub-series, which is found in the 9.6, 9.6.1, and the 9.9. Now we will be coming out with memos in more detail on each of these endorsements, getting into more of the mechanics. But I think for now it's important for you to see what the structure is. Now, note also that of these endorsements up here, the one that is still charged at a percentage is the 9.7, which is charged at 5% of the premium, and that is unfortunately replacing a endorsement that is charged currently at 10% of the loan. Let's talk a little bit about the Alta 28. There are two basic types of Alta 28 endorsements. There's the Alta 28, and then there's a series of derivations of it, but they actually, these 0.1, 0.2, and 0.3 variations actually are mechanically a little different from the 28-06 itself. Notice also there's a little curveball here, and you'll see that of the 1, 2, and 3, the 1 is actually the 2021 version. When you do not see a year letter, a year, like a -06, that generally means that it is part of the 2021 vintage of the Alta form. There's two basic types. The original Alta 28 was crafted for easements generally, but the way it was worded specifically added addressed constant. I'm sorry, but the specific, but the way it was worded specifically addressed consequences of damage or enforcement or enforced removal of existing buildings. As the endorsement itself says, the company insures against loss or damage sustained by the insured if the exercise of the granted or reserved rights to use or maintain the easement referred to in exceptions, and then there's a blank of Schedule B results in 1, damage to an existing building located on the land, or enforced removal or alteration of an existing building on the land. Mechanically, this means that you add the exception number containing the easement, which you're trying to generally accept to. The remainder of the Alta 28 series functions a little bit differently. They each address encroachments by insuring against loss or damage sustained by the insured by reason of an encroachment of any improvement or future improvement located on the land onto adjoining land, or onto that portion of the land subject to an easement, or an encroachment of any current improvement located on adjoining land onto the land. They address enforced removal by insuring against loss or damage by reason of enforced removal of any improvement or future improvement where applicable, located on the land that encroaches onto an adjoining land or that encroaches onto any portion of the land subject to the easement. Now, I apologize for the technical language here. I mean, it's kind of hard for me to even read that without realizing it's hard to listen to. But like I said, we are going to be providing written materials on all this that go over it in written form. Now, let's see, why don't we talk a little bit about the Alta 35 series. Actually, let me talk a little bit about what these variations are. Okay, so the 28-06 covers loss or damage or enforced removal of existing buildings. It's given to provide a type of affirmative insurance in connection with easements identified in Schedule B, namely any rights in that easement that cause the insured damage to an existing building located on the land, or enforced removal or alteration of the building. Now, the cost for this endorsement is $50 per owner's policy, $250 for a commercial owner's policy, $50 for a residential loan policy, and $250 for commercial loans. They are for 1 to 4 family residential or 125. I think this said million. No, I'll forget. I'm not sure what the 25 is referring to. I will have to get back to him. In all of these, a survey is required. Both the 2006 and 2021 versions of the Alta 28.1 share several common features. Both define an improvement as an existing building located on either the land or on joining land at the date of policy, and that by law constitutes real property. It's subject to the exclusions provided in paragraph 4. In both versions, paragraph 3 provides 4 items of affirmative assurance against an encroachment of any improvement located on the land onto adjoining land or onto that portion of the land subject to an easement, unless an exception in Schedule B of the policy identifies the encroachment. An encroachment of any improvement located on adjoining land or onto the land at the date of policy, unless an exception in Schedule B of the policy identifies the encroachment. Enforced removal of any improvement located on the land or as a result of an encroachment by the improvement onto any portion of the land subject to an easement. In the event that the owners of the easement shall, for the purposes of exercising the right of use or maintenance of the easement, compel removal or relocation of the encroaching improvement, and the enforced removal of any improvement located on the land that encroaches onto the land. The changes made by the 2021 version of the form here is that in the 2021 version are basically matters of form. First, the exclusions provided by Section 4's reference to Schedule B are now only applicable to Sections 3C and 3D of the endorsement. There's really not a substantive difference, though, because Sections 3A and 3B still contain independent reference to Schedule B. Another cosmetic difference is that the 2006 version provided for the exclusion of encroachments listed as exceptions, whereas the 2021 version more broadly accepts enumerated exceptions. Again, there's a little practical difference here. As mentioned earlier, it's $50 for an owner's policy, residential owner's policy, $250 for commercial owner's policy, $50 for residential loan, $250 for commercial. The 28.2. Again, $50 for residential owners, $250 for commercial owners, $50 for residential loan, and $250 for commercial loan. Same general underwriting requirements for the 28.2 as for the 28.1, but the specifically itemized improvements must be listed in paragraph 2 of the endorsement. The Alta 28.206 can be issued along with 28, but not together with the 28.1 or 28.3. Changes made to the 28.1 to create the 28.2, which is found in the identified improvements version, are small but significant. The reworking of the Section 4 exclusions discussed above were first implemented in this 28.2 form, and you'll similarly find Section 4 now references only in 4C and 4D. The more important difference here is that the term improvement refers to an itemized list. For example, a fence, shed, garage, or patio, which must be populated for the endorsement to have any value. Each improvement for which the insurance is to be provided must be enumerated. The 28.3 for encroachments, boundaries, and easements, land under development, costs the greater of $500 or 5% of the premium for the owner's policy. If issued simultaneously with an owner's policy, the loan policy endorsement, the one for the loan policy endorsement is the greater of $250 or 5% of the premium. If it's not issued simultaneously, then it's the greater of $500 or 5% of the premium for the loan policy. Again, same general underwriting requirements for the Alta 28 as for the Alta 28.1, but this endorsement also requires a building site and elevation plan showing all future improvements on the property, which makes sense, of course. The Alta 28.3 can be issued with the 28-06, but not with the 28.1 or 28.2. The term improvement is tweaked a little bit here in this endorsement to include road and driveway elements. Specifically, improvement is defined to mean, and as you can see here, a building, structure, or paved area, including any road, walkway, parking area, driveway, or curb located on the surface of the land, on the surface of adjoining land at the date of policy, that by all constitutional property. Okay, now we'll talk about the Alta 35 series. So like I mentioned earlier, the Alta 9 was split off into other series, and this is another series. The original restrictions, encroachments, minerals, comprehensive endorsement was split off into the 35 series mineral endorsements. These endorsements provide coverage for damage caused by the enforced removal of an improvement as specifically defined in each of the endorsements, from the exercise of a right to use the surface of the land to extract or develop minerals or other subsurface substances. This coverage was previously included in the former comprehensive Alta 9 series and still survives in the revised Alta 9-06 and the new, well, the only one for our purposes, Alta 9.7-06, which is the land under development version. But it's been otherwise removed from that series of endorsements. As you recall, the original comprehensive Alta 9 covering restrictions, encroachments, and minerals was split up into several sub-series, more specific to individual coverage areas where some portions of the coverage were not appropriate. The Alta 35 coverage excludes loss or damage from contamination, explosion, fire, vibration, fracturing, earthquake, or subsidence or negligence by the extracting party, and any other matter explicitly excluded within the blanks of the endorsement itself. The four Alta 35 series of endorsements substantively differ only in how the term improvement, i.e. the thing that could be damaged and against which coverage is provided, is defined. In the Alta 35, in the Alta 35-06 endorsement, which is entitled Minerals and Other Subsurface Substances - Buildings, improvement simply means a building located on the policy. In the Alta 35.1-06 endorsement entitled Minerals and Other Subsurface Substances - Improvements, improvement has a broader default meaning as a building structure located on the surface of the land and any paved road, walkway, parking area, driveway, or curb affixed to the land at the date of policy, and that by law constitutes real property, but excluding any crops, landscaping, lawn, shrubbery, or trees. In the Alta 35.2-06 endorsement, which is entitled Minerals and Other Subsurface Substances - Described Improvements, improvement means each improvement on the land at the date of policy, specifically described and itemized on an exhibit which you attach to the endorsement. In the Alta 35.3-06, entitled Minerals and Other Subsurface Substances - Land Under Development, improvement has the same meaning as found in the Alta 35.1-06. It means that improvements, it has the same definition as provided in 35.1, but the terms future improvement and plans are added as definitions to reference the improvements under development, and the endorsements coverages are explicitly extended to those future improvements. The Alta 35 series can be added to either owners, loan, or construction policies, although it's a state-by-state issue. All four endorsements are typically available on commercial property, and the first three are typically available for residential property. Coverage under the Alta 35 endorsements will generally be available where there has been no severance of the mineral, subsurface, and surface rights in the land. In other words, someone has not already conveyed those mineral subsurface rights separately, and that they're still one and the same. The surface hasn't been separated from the rights of the minerals underneath it. When those mineral or subsurface rights are severed from the surface rights, it's typically the subsurface rights which are the dominant estate. And this will potentially create a conflict for us in providing the endorsement. Those situations are going to require even more special attention to see whether the exercise of those rights would actually likely damage the improvement. Okay. Jumping around in here a bit, because we need to now talk about the Alta 36. We'll jump back to those earlier slides. The Alta 36 of series of endorsements is yet another type of series of endorsements that can be somewhat traced back to the Alta 9. They were designed to address the needs of electrical energy generation projects, sunlight and wind, their sources. So what is special and distinct about these projects? Well, for one thing, and by the way, this is the series of endorsements that is referred to as the energy endorsements. In fact, you'll see if you look at the new Alta manual that has been distributed, each of these endorsements is titled in some way energy project. So both solar and electrical generating projects require windmill and sunlight electric generating projects require relatively expansive footprints, covering a great deal of land. And because of that, these projects often span many different properties and tracts. And so if you had a gap or a disruption in a portion of those parcels, it can affect the viability of the entire project. So if you had a big solar farm and someone said, well, I can build a farm in between this, or I can pave a road in between your project, that could have real dire consequences. If you have a whole bunch of solar cells set up there, you got cables running underneath them. You want to basically ensure that all these parcels together can be used for the project. And whatever restrictions are in place, they've been known ahead of time what they had to deal with, and they don't have to come back at some later period and accommodate some other person's right to use the land in some way that would compromise that project. One of the important things that several of these endorsements therefore do is they provide a paradigm for dealing with title spanning projects as a single project. And as such, all the endorsements all contain a definition for a constituent parcel. Another common thread running through the endorsements is that the value of the project is in large, perhaps even majority part, represented by the infrastructure of the projects. Electrical generation projects oftentimes are built upon not fee title ownership, but a lot of times they're built on leaseholds and on easements, based on easements and leaseholds. The value of these interests in themselves is not where the true cost of the project comes into play, but instead is represented by the solar panels and the windmills. And as such, all the endorsements share a definition and concept of an electrical facility and several bold improvements. I'm going to jump back to some of these earlier slides. Talked about the valuation as an integrated project. Okay. We'll get over to cool. There we go. All these share concepts of an electrical facility. Where's my slide? Electrical facility. Here we go. An electrical facility is defined in each of the various versions of the policies to include the infrastructure you would typically see in a solar or wind energy project. Specifically, it means an electricity generating facility, which may include one or more of the following: a substation, a transmission, distribution, or collector line, an interconnection, inverter, transformer, generator, turbine, array, solar panel or module, a circuit breaker, footing, tower, pole, crossarm, guy line, anchor, wire, control system, communications or radio relay system, safety protection facility, road or other building, structure, fixture, machinery, equipment, appliance, and items associated with or incidental to the generation, conversion, storage, switching, metering, step up, step down, conversion, transmission, conducting, wheeling, sale, and other use or conveyance of electricity on land, and this is the important part, at data policy or to be built or constructed on the land in the locations according to the plans that by law constitute real property. Looks like part of my slide got cut off here. So the important thing again is these are all things that are on the land at date of policy or to be built or constructed on the land in the locations according to the plans that by law constitute real property. So we're going to talk about that a little bit more in a moment. So more than the iteration of types of fixtures, it is the end of the definition that's really important. An electrical facility is infrastructure that state law would regard as real property. Now, a severable improvement is the other variety of infrastructure. It means property affixed to the land at date of policy or to be affixed in the locations according to the lands that would constitute an electrical facility, but for its characterization as personal property, and that by law does not constitute real property because of its character and manner of attachment to the land, and the property can be severed from the land without causing material damage to the property. So let me just kind of put these two things together. An electrical facility and a severable improvement are both referring to electrical generation infrastructure. But electrical facility is really referring to that infrastructure that would be regarded as permanently affixed to the land and therefore real property. And a severable improvement is that energy infrastructure that can be essentially packed up and carried off, and is not the fixture. Each of the endorsements deal with these two concepts to a greater or lesser extent. Okay. So the 36-06, the 36.1-06, which are both for leasements and easements, the 36.2 and the 36.3-06, which are for leasements only, leaseholds only, include in the definition of eviction the lawful prevention of the use of a severable improvement. They provide rules for valuing the severable improvement and except from coverage issues relating to the perfection of a security interest in a severable improvement. Remember, these are not real property interests after all, and the Alta loan policy, the Alta policy endorsement is attached to a policy of real property title insurance, which makes sense, right? If something is not affixed to the land, it is not real property. It would not be covered under the land title insurance policy that Alta writes. These four endorsements provide coverage for the cost of removing and relocating the severable improvement. So that is, in a way, it's coverage that is somewhat related to that non-real property interests. Again, this is the affirmative insurance that we're talking about here. The 36.4. There we go. 36.4 and 36.5-06. Covenants, conditions, and restrictions, land under development, provide coverage for the violation of an enforceable covenant by a severable improvement, and for enforced removal of a severable improvement as a result of a violation of a building setback line. In all cases, unless an exception to such coverage is made, in Schedule B. All right, I don't seem to see my 36.6 line. 36.6-06 encroachments provides coverage for an encroachment of a severable improvement located on the land onto adjoining land or onto that portion of the land subject to an easement. Enforced removal of any severable improvement as a result of an encroachment by the severable improvement onto any portion of the land subject to any easement. It provides coverage for damage to a severable improvement that is located on or encroaches onto that portion of the land subject to an easement except in Schedule B. Just wait 1 second here. Just one moment, I'm just going to bring us back to my 36 series chart. The 36.7-06 and the 36.8-06 fee estate deal with severable improvements in a similar fashion as the 36.36-06, but substitutes eviction for ejection. It provides rules for valuing a severable improvement and accepts from coverage issues relating to the perfection of a security interest in the severable improvement. These two endorsements provide coverage for the cost of removing and relocating the severable improvements. The 36-06 for owners and 36.1-06 for loan cover projects assembled from leaseholds and easements. Special terms are added to the policy for valuing the integrated project as a whole. Sorry, just finding my place here. When there has been an eviction from one or more of the constituent parcels. So special terms are added to the policy for valuing the integrated project as a whole when there has been an eviction from one or more of the constituent parcels. Provides rules for valuing the severable improvement and accepts from coverage issues relating to the perfection of a security interest. The 36.2 for the owners and 36.3-06, they're basically the same endorsement as the 36-06 and the 36.1-06, but references to easements are stricken. In other words, you would not use those two endorsements for easements. These four endorsements, let me go back to that chart. These four endorsements, the 36-06, the 36.1, 36.2, and the 36.3, provide coverage for the cost of removing and relocating severable improvements because of a violation of a leasehold and/or easement, as applicable. In both cases, the loan policy version of these endorsements is nearly identical to the owner's policy version, except that the loan policy version adds a definition for tenant and replaces references to the insured as an objection as the object of an eviction, and replaces references to the insured as the objection of an eviction in its covered risks to that of a tenant. The 36.4-06 and the 36.5-06 for covenants, conditions, restrictions, land and development provide coverage for the violation of an enforceable covenant by a severable improvement and for enforced removal of a severable improvement as a result of a violation of a building setback line. In all cases, unless an exception to such coverage is made in Schedule B. This pair of endorsements, 36.4 and 36.5, are much shorter than the first four we just reviewed. And instead of providing detailed terms for valuing the electrical facility and the severable improvements as part of a completed integration project, as these are endorsements for land under development. These endorsements instead define these terms in the context of the project's plans and provide coverage for violations and enforced removal of these items because of a violation. The loan policy version of this endorsement adds an additional covered risk for violations that undermine the lien of the insured mortgage or that cause a loss to the insured lender after the lender takes back the property foreclosure. The 36.6-06 encroachments variety of the 36 series provides coverage for an encroachment of an electrical facility or severable improvement located on the land, onto adjoining land, or onto that portion of the land subject to an easement. It also provides coverage of the reverse and encroachment onto the land from an adjoining parcel. It provides coverage for forced removal of any severable improvement as a result of an encroachment onto any portion of the land subject to an easement. It provides coverage for damage to an electrical facility or severable improvement that is located on or encroaches on to that portion of the land subject to an easement accepted in Schedule B. This endorsement does not insure against loss or damage, and the company will not pay costs, attorney's fees, or expenses resulting from contamination, explosion, fire, flooding, vibration, fracturing, earthquake, or subsidence. The 36.7 and the 36.8 for fee estate deal with electrical facilities and severable improvements in similar fashion as does the 36-06 and the other in that series. But these endorsements cover fee interests instead of easements and leaseholds. They substitute eviction for ejection. It provides rules for valuing the project as a whole and the severable improvements, and accepts from coverage issues relating to the perfection of a security interest in a severable improvement. These two endorsements provide coverage for the cost of removing and relocating those severable improvements. As with the other 36 series, the loan policy version makes subtle changes. In particular, a new defined term of vestee is created to refer to the object of an ejectment, and that term vestee replaced insured in the covered risks. This endorsement does not insure against loss, damage, or costs of remediation, and the company won't pay costs or attorney's fees resulting from them, which are the result of environmental damage or contamination. Now, let's see, we talked about the electrical facilities, solar farms, wind farms, the idea of a constituent parcel, electrical facility as that part of the electrical infrastructure that is real property. We talked about severable improvements as that part of the electrical infrastructure that is not real property. We talked about the definition for an electrical facility and severable improvements. Talked about how these endorsements seek to value the project as a whole. But also, it's important to note that they also look to eliminate the duplication of losses. So by nature, these endorsements are covering multiple real property interests, and you could foreseeably have losses relating to the constituent parcels. And what these endorsements try to do in their wording is to prevent that type of loss from basically double dipping on the same loss. We talked about how how severable improvements in general are covered in the cost of removing them, but the valuation of them includes the diminution of value as the result from an eviction or ejection. Remember, eviction or ejection turn on whether or not you're dealing essentially with a leasehold, easement, or a fee estate. These endorsements contain additional coverage for moving severable improvements and the fair market value of the remaining lease or easement terms, but disclaim liability for environmental damage. Talked about the fact that these energy projects oftentimes involve many different property owners and different varieties of ownership interests, or real property interests rather. In general, not that this is really relevant to underwriting, but solar farms are general. Well, it is in terms of if you're underwriting a solar farm, but they're generally less tolerant of gaps or holes than wind farms, which obviously makes sense. Solar farms are more likely to be contiguous, meaning there's no actual gaps between them, whereas a wind farm could actually look like something like a checkerboard. Sometimes you might see these windmills that are enormous, and there's huge distances between them. We talked about the fact that most of the cost of these energy projects is found in the infrastructure, and that's why these endorsements try to focus on that infrastructure. Talked about eviction, ejectment are triggered off. Talked about relocating several improvements, coverage for rent. They do not provide coverage for environmental damage or contamination. Talked about the different forms that are available for owners and loan when they are based on leaseholds. This slide, okay. I'm going to, Catherine, I think I'm going to hand it back to you so we can continue on with the remainder.
Okay, thank you, Vince.
Right.
I'm sorry, I just need control of the slides. Okay, thank you. Everyone should be seeing standard New York endorsements as a slide. And we appreciate you, hanging with us. This is dry stuff. It's a lot of educational mumbo jumbo that, we were required to do. This is insurance, so it's kind of boring. So we appreciate that. If you notice from what Vince's presentation said, there are now endorsements for owners policies. So this is an extra revenue stream, but owners are allowed certain coverages. We just have to be more careful with them. We've always had this thing, oh, we don't put anything in owners policies, but we can give it to the loan because it's a much easier bar that we have to meet. It's not as risky as to put in an owner's policy, but they have crafted these endorsements carefully so that we can give our owners certain protections. And we want to make sure that we underwrite those correctly, so we're not exposing ourselves to more risk. The TIRSA and a lot of these changes also that we have, some of them are just practically cosmetic. If you look at the screen, the standard New York endorsements, the loan policy, it references to, it used to reference to exclusion 7. Exclusion 7 is now exclusion 8, so we've updated that to the 2021 policy. The definitions that may have been made throughout the rate manual, they will be updated as well. So the only things changing in the New York endorsements is the direction they point to in the actual policy jacket. No big issue. Next is the additional interest endorsement. This is additional interest for loans, not interest in land. The TIRSA additional interest and interest rate swap endorsement have a lot in common, notwithstanding their disparate form titles. Both of these forms provide insurance against the risk that additional loan interest will not enjoy the same priority as other indebtedness secured by the mortgage. As such, it should be understood that the term additional interest in the context has to do with additional loan interest, not additional property interest. So it could be considered a more general variety than the swap endorsement. You're not going to use this much often. The initial endorsement is for pretty much any possible scenario where additional interest can be charged. The underwriting involved in these endorsements is about ensuring that the loan terms do not run afoul of usury laws that would inhibit the ability of the lender to collect the additional interest. And you see on the screens the changes that were made. The one on the left is the old form, and the one on the right is the new form. They cleaned up a couple of these paragraphs for you. Vince, I'm going to switch back to you for aggregation. I'm just going to leave this on the screen.
Okay, great. I was going to show you the, if you would like to take a look at the Alta 12.6, the actual endorsement itself Both of these endorsements, the 12-06 and the 12.1-06, are for aggregation of different loan policies. One thing that is very important to keep in mind about the Alta 12 is that it is currently labeled in the TIRSA manual as an unmodified Alta form, both the 12 and the 12.1. There's no indication in there that they've been modified, but these forms have actually been modified, and they've been modified actually in ways that are not necessarily that substantive from what the original form is in Alta, but really comes from the fact that these forms are being adopted at the same time as the Alta 2021 policies have been adopted. And you'll recall that I mentioned that part of what TIRSA did in this latest filing was to update the actual insurance forms from the 2006 versions to the 2021 versions. Now, the two versions of the Alta 12 that TIRSA adopted, somewhat interestingly, were the 06 versions. So what you actually are seeing in the TIRSA manual is not the Alta 12-06 and the Alta 12.1-06. What you are actually seeing is a modified version of these two. And my prediction is this may be the subject of a future revision in the TIRSA manual to either more explicitly refer to them as a New York variation of an Alta form, or maybe they will just simply be rebranded as TIRSA forms. But very important thing to understand, if you are a multi-state agent, this is a form you need to be very careful about, because if you're producing policies in multiple states, you may be using, for example, unmodified Alta forms in all the states that have adopted unmodified Alta forms. For example, the loan policy itself, right? So you might end up using this now you might end up using the same 2021 loan policy that you're currently using in New Jersey, and now you're going to use it in New York. You got to be careful if you're talking about the 12 and the 12.1. Now, mechanically, what do these? Thank you, Catherine. So mechanically, what do these forms do? These forms allow multiple loan policies to be aggregated together. Both of the endorsements cost $50. They both, in the first part of them, they recite the policy numbers, the states, and the amount of insurance for each of the policies to be aggregated. In the next section, the amount of insurance available to cover the company's liability for loss or damage under the policy at the time of loss is specified to be the aggregate amount of insurance defined in section 3. Section 3 provides a fill-in for us to include that aggregated amount. Section 4 of this endorsement modifies, and this is really where the meat of the changes that TIRSA made come into play. And it makes sense because in sections 4, 5, and 6 of this endorsement, it's actually changing the conditions of the underlying loan policy. So in section 4 of the endorsement, it modifies condition 7 regarding available options for the company to pay or otherwise settle claims. And it generally provides the company is given the option to choose either the amount of the insurance under the component policy or the applicable or the aggregate amount of insurance provided under the endorsement. The change that TIRSA made in this endorsement is essentially to make this change that it makes more in conformity with how the 2021 version of the policy form is drafted, and not as the 2006 version was. Section 5 of the endorsement modifies condition 8 regarding determination of the amount of the liability to set the maximum at the aggregate amount of insurance instead of the amount of insurance. So if you're reading that policy, and attached to that policy has been one of these endorsements. Where that policy refers to an amount of insurance, it's actually going to now instead refer to an aggregate amount of insurance. And in section 6, it modifies condition 10, which concerns the reduction of insurance. And it does this in a way for it to, like in the previous paragraphs, to make it work with the aggregate amount of insurance instead of the amount of insurance specified in the policy. Now, the 12.1, which is entitled Aggregation Endorsement dash State Limits dash Loan Policy, it's essentially the same thing as the 12-06, but the 12.1 enables the company to limit, really to firewall off from aggregation the amount of one or more of the policies identified based upon the state where the property is located. Now, the corresponding section of the manual that talks about the use of these endorsements somewhat belies the use of them in a multi-state environment. If you look at manual section 14, which is the portion of the manual which deals with this, you'll see that it is relating to instances where the property is identical in the loan policy. So that would seemingly cause something of a difficulty in insuring it in a multi-state environment, I presume. Catherine, that's all I think I have for the Alta 12.
Yeah, thank you, Vince.
Or the TIRSA 12. Maybe we should be calling it.
Whatever it is. Okay, back to the rest of the endorsements. These are endorsements you're not going to see too much. We tried to front load this presentation with the ones you're really going to use more. This next slide is for co-insurance. That's when you have these, multi-million-dollar deals and every underwriter has a piece of it. There's a co-insurance endorsement and there's a co-insurance multiple policies endorsement. Now, the main change to these are that cause each of the co-insurers to adopt the other insurers' covered risks, exclusions, conditions, and endorsements. But the 23.1 excludes the 12-06 and the 12.106, which Vince had just explained. What that means is if you raise this and I raise that, we're all adopting each other's risks, et cetera, that we have taken on and the exclusions that we've made. So it's all a cohesive co-insurance policy. The Alta 19 series contiguity used to be 1, now it's 3. The multiple parcel, the single parcel, and the specified parcel, the cost of this endorsement is $50. For the multiple parcel endorsement, it ensures a contiguity of several insured parcel. So if I'm buying 3 tracts of land, the contiguity 19-06 will ensure the contiguity of those 3 parcels. If you have a single parcel, you use a 19.1-06. This is insured parcels. Insures against the failure of a single parcel to be contiguous to its nearest parcel. So this is to ensure that there are no gaps between you and your neighbors. Gaps, strips, gores. The external parcel must be specified. So you have to say, I'm lot 1 and lot 2, 3, and 4 are contiguous to me. Specified parcel endorsement is a group of parcels that specified is insured against gaps, strips, and gores. This is just to make sure they're all contiguous. It may be a combination of insured and uninsured parcels, but they split it up to make everything more specific. Next slide is commercial contract BenG endorsement, probably not generally used. This is for commercial contracts, and it added a specific reference to Article 2 of the New York lien law for mechanics liens. Again, in your residential everyday practice, you're not going to use this one. The cooperative endorsements, the loan policy and the owner's policy, same thing that they did. One covered risk eliminated. The premises not being part of a cooperative regime validly created pursuant to the laws of the state of New York, subject, however, to the terms and provisions of the offering plan as amended. So that is eliminated as a covered risk. Now they're on their own. Updated references from 2006 to 2021 numbering. A lot of these things, you know, because of the transition, conditions change, numbering changes, things get eliminated like you see, and they just renumber things and make them. So there's a lot of endorsements have this type of thing. The Alta 20-06, the first loss multiple parcel transactions endorsement. This is only if you have multiple parcels. If there are two or more parcels of real property being insured. Endorsement charge is 10% of the loan rate or construction mortgage rate is applicable. And this is one of the underwriter approval endorsements. We do have a lot of underwriter approval endorsements, unfortunately, but until we get used to the rhythm of doing this, we really have to keep tight on these requirements. From the endorsement, paragraph 2, in the event of a claim resulting from a matter insured against the policy, the company agrees to pay that portion of the material impairment amount that does not exceed the extent of liability imposed by Section 8 of the conditions without requiring maturity of the indebtedness by acceleration or otherwise, pursuit by the insured of its remedies against the collateral, or pursuit by the insured of its remedies against any guarantee, bond, or other insurance. Again, you know, this is more of a commercial type of situation. You may not see this in your everyday residential practice. Joint and several liability. This is a major change. They added an entire paragraph. Notwithstanding the foregoing, in the event of a claim of the co-insurance policy that results in loss and damage, the insured shall have the right to elect any one of the co-insuring companies to be liable joint and severally for such loss. This is, again, when you have core insurance, there are 5 title companies on the matter because it's, you know, $1 billion. This allows a joint and several liability election to any one of the co-insuring companies and not all of them. They can choose who they want. Joint and several election and joint and several obligation does not affect the liability of each of the co-insuring companies to pay costs, attorney's fees, and expenses provided for in the conditions. And they have the right to exercise the election one time. And here are the changes that are the joint several liability. As you see, there are blanks to be filled. Again, if there's a blank in endorsement, please make sure it's filled. It's very important. Otherwise, you know, we could be liable for something that we'd never agreed to. Okay, TIRSA market value endorsement for the taupe has been eliminated. It's been the TIRSA market value endorsement is now the replacement for any market value rider. We're investigating whether this endorsement now applies to the taupe policies as well. But this is the very, very long title of the market value rider as replaced. Vince, do you want to talk about mezzanine financing?
I just needed to unmute myself. Sure. The mezzanine financing endorsement. The new manual contains a new variety of mezzanine financing endorsement called the mezzanine financing assignment of proceeds endorsement. For those that attended our last seminar, I explained that the mezzanine financing endorsement assigns the owner's policy amount to the mezzanine lender and requires the mezzanine lender requires the mezzanine lender to be contacted to further modify the policy. It also involves waiving the exercise of certain policy conditions related to the imputing of knowledge of the insured, and the insured agrees that it will not deny payment to the mezzanine lender because the mezzanine lender has already acquired ownership of the insured. So basically what it does is, it is for instances where a loan is being made and is secured not just by, not by a direct interest in the real property, but is secured by a personal property interest in the owner of the insured property. So now, so it is an endorsement that is provided to a lender that has lent money based on essentially share certificates in the entity which owns the real property. All right, and those certificates are personal property interest. These endorsements are, however, attached to real property title insurance title policies. So what happens is you have a mezzanine borrower. You have a borrower that has also taken out a mezzanine loan, but this borrower is a borrower on a normal loan policy. The mezzanine lender wants as further security for itself to be added essentially as an additional insured. I don't know if you've ever had any other kinds of policies where you add, like this often happens when it comes to malpractice policies and professional liability policies or fidelity policies, where some client or what have you asks you to, I want to be an additional insured under your policy. I want to be involved. If there's ever kind of any loss, I want to be able to deal directly with the insurance company. And basically a certificate holder. And so that's essentially what the mezzanine financing endorsement does. But it does something more. It also, when you have a claim against an insured, so this is an endorsement provided to a lender, but it's based on an owner's title insurance policy. And when you issue an owner's title policy, the knowledge of that insured, whether that insured might know of some kind of matter that could result in a claim, that's part of the reason why we have that insured sign a title affidavit, right? We want to know what that insured knows. We want to know what their knowledge is, and we're going to disclaim from coverage things that they should have told us when we were originating the policy. Well, the mezzanine lender doesn't want their coverage limited by that. And so what the mezzanine financing endorsement does is it says, you know what, we as the insurer, we're not going to exercise against you, the mezzanine lender, essentially an additional loss payee on the owner's title insurance policy. We're not going to impute their knowledge to you in whether or not we cover your claim. And that's why it actually has a real charge for premium based on the percentage of the basic premium. The mezzanine financing assignment of proceeds endorsement, which only carries a flat fee, is actually, I believe it's $50, is much more limited. It literally is just essentially adding the mezzanine lender as a loss payee. It is not giving that lender, the additional escape hatch of having that knowledge not imputed to the lender. So if the owner did hold something back in the origination of that owner's policy, and it's a defense against that owner, well, the mezzanine financing assignment of proceeds endorsement is not going to come to the rescue like the regular mezzanine financing endorsement would. Like I just mentioned, it doesn't waive imputation of knowledge exclusions, and that is the crucial issue, and that is really why the assignment of proceeds endorsement is reflective of just a simple administrative change in who the loss payee is on the owner's policy. Catherine, I think that's all I got for those two.
Okay, great, thank you. Next up is the TIRSA New York City Development Rights Endorsement. This one's been kicking around for a while. A couple of changes. It's only, it's always only for New York City. The endorsement defines a few important terms. The declaration of zoning lot restrictions, the zoning lot development agreement. As to the declaration, the endorsement ensures that the proper parties have entered into it. That is, that all the parties of interest, as the term is defined in Section 12-10 of the zoning resolution of the City of New York, effective December 15, 1961, have joined in. Whoops, sorry. As to the ZLDA, the endorsement ensures that the ZLDA is effective to transfer or allocate floor area development rights, but does not ensure any particular amount of transfer of such rights. The new form makes it more clear that an optional paragraph may be added to the form, incorporating any easement for light and air over specified lots as set forth in the ZLDA. Right here. The cost of the endorsement can proceed according to two basic scenarios. By default, the per policy cost is $25. If it's being issued on multiple policies at the same time in a simultaneous issue, you only charge for the owner's policy's endorsement. The others get it free. The other way the endorsement can be charged is when issued to provide supplemental or additional insurance to a current insured who has subsequently acquired rights pursuant to a ZLDA, and the current insured now wants the benefit of the NYC developmental rights endorsement. In that case, instead of normal rules for minimum insurance for owner's policy, the minimum amount of insurance for this particular scenario would be subject to the overall minimum policy premium specified in the manual. The total consideration paid for any development rights transferred pursuant to the ZLDA right recited in the endorsement. So you see the changes up on the screen. There are a lot of blanks to fill. They made it a little more comprehensive, and it's only for New York City. The option endorsement has just been rewritten in its entirety and new definitions added. As we explained, there's a lot of new definitions in the rate manual, so those have been added. And the rate rule is in the process of being rewritten. There was a little something on TIRSA's end that they wanted to clean this up, so they're going to change that rate rule and resubmit to the DFS for approval. Partial release of mortgage premises. You see the changes on the screen. Company, again, it's company instead policy insures against loss or damage sustained by the invalidity, unenforceability, or lack of priority of lien of an insured mortgage on the portion of the land not subject to the release of a portion of mortgage premises made by so-and-so, fill in your blanks, and to be recorded solely by reason of the execution, delivery, or recording of the partial release. And this has been expanded, but this paragraph has been expanded in all the endorsements, if you noticed our note in the beginning. Not too much of a change here. The residential revolving credit endorsement, these are usually for credit lines when they are insured. There were 4 RCE endorsements, revolving credit line endorsements. Now there are 3. So we have RCE1, RCE2, and RCE4 has been renumbered to RCE3. RCE3 has been eliminated. It was an alternate version of the RCE2 for limited term special coverage. So the residential revolving credit owner occupied 1 to 6 family endorsement, that has remained RCE1. The commercial revolving credit endorsement for commercial credit lines less than 3 million is RCE2. And this is former RCE4, which is over $1 million for commercial revolving credit lines, is now RCE3. As you see, the residential mortgage endorsement, not too many things here. You see there's added definitions. Insures against loss of the forced removal of any improvement located on the land as a result of encroachment by the improvement onto any portion of the land subject to any easement listed as an exception in Schedule B. In the event the owners of the easement shall, for the purpose of exercising the right of use or maintenance of the easement, compel removal or relocation of the encroaching improvement. See a lot of capital letters here. This means that they are in defined terms in the rate manual. So some of these have been added. And they cut this paragraph into a violation of a covenant that divests, subordinates, or extinguishes the lien of this insured mortgage. Again, this is only for mortgages. There's no alternate new owner's version. It results in the invalidity, unenforceability, or lack of priority of the lien of the insured mortgage, or causes a loss of the insured's title acquired in satisfaction or partial satisfaction of the indebtedness, or a violation of the land of the policy of an enforceable covenant unless an exception in Schedule B of the policy identifies a violation. Otherwise, you use it the same. Residential endorsements are almost in every loan 1 to 4, but it does, strengthen the terms a little. The reverse mortgage endorsement, still a free endorsement. It's revised to work certain paragraphs that needed a little cleaning up, and that's about it on that. We're giving you a lot more information that you need. I mean, it's good for you to educate yourself as to the actual content of these endorsements, but it's more learning how to use them and making sure that you're using the proper endorsement for your situation. That is going to be the biggest learning curve. Land same as survey. It used to be just 1 endorsement. Now it's 2. 1 endorsement is when the survey covers the premises under examination plus more. I had made the example before about row houses. You have a survey with 5 row houses on it, and you're only selling 1. You're only insuring 1. You have to use the same as a portion of the survey. Your property isn't the only thing on the survey. There are other uninsured parcels on that survey that is being used. And the land same as survey is when the policy is the same. You have 1 lot, you're insuring on 1 survey, and that's it. Nothing else extraneous on the survey described. The TIRSA successor and ownership of insured mortgage endorsement, only for a loan policy, obviously. The company hereby extends the benefits of the policy to the assignee as of the date of policy, but only to the extent that the insured mortgage and the notes or obligations secured thereby have been properly and validly assigned and delivered to the assignee, and subject to the exclusions contained in this endorsement, the exclusions from coverage in the policy, and the provisions of the conditions and the exceptions contained in Schedule B of the policy. This is when the party that's been assigned the mortgage wants this endorsement just to make it absolutely clear that they are the new insured, but they have to take subject to anything that's in the old policy, good and bad. Interest rate swap agreement, additional interest. It's a defined amount endorsement. If there's an interest rate exchange agreement, this endorsement ensures the priority of the loan as to possible additional interest. And that has to all be defined in the loan agreement. Alta 40 series, this is a new set of endorsements, tax credit endorsements. They have, these are for owner's policy. Extends coverage to a tax credit investor, any tax credit in effect at the date of policy that pertains to the land. Requires that the tax creditor investor to establish the reduction in the amount of the tax credit, among other things. So if the investor has a tax credit against the land, it gets reduced for some reason that was not known at the time, but could have been discoverable. Any tax credit that was in effect that gets reduced, they would be covered under these series of endorsements. Tax parcel endorsement. We have both single and multiple tax parcels, depending on what you're insuring. Policy insured against loss or damage due to the land being taxed as part of a larger parcel or failing to be separate as a separate parcel. You'll see this with subdivisions. You'll see this with new condos. We raise it all the time, that if the taxes haven't been apportioned, we're accepting the effect of any apportionment. But this endorsement, if the lender does take it, insures against loss or damage due to the land still being taxed as part of a larger parcel, and then something happening like a tax sale or that our property gets caught up in. And multiple tax parcel is the same thing. Under the given tax lot numbers, there should be a fill-in as to specify the tax lot numbers, including any additional land. Tribal waivers. This is a new tribal waivers endorsement. There were problems in, I believe it was Michigan, in a case where it happened on tribal lands and they couldn't get jurisdiction over them in order to make a claim, bring a lawsuit, and resolve an issue. So this tribal waivers endorsement is for any tribal owned land the tribe or tribal entity waives sovereign immunity and consents to federal and state court jurisdiction. Now this is huge because otherwise you can't reach within the tribe in order to obtain jurisdiction over them. And therefore you have no defendant in your action if you have to bring a claim. Is not just an endorsement, it requires a waiver and it requires the signature of the tribe, very important, and must be used when land is or may be in a tribal area. Just watch this one because New York has lots of tribal areas. It's Shinnecock, it's upstate. There are plenty of places that are in tribal areas. So if you have some sort of knowledge that this is in a tribal area or even think you do, make sure this goes in because this is a huge issue if we have a claim. Usury endorsement, this you're not going to see too much. It cannot be issued under policies under $2.5 million. It's only issued with loan or construction policy. It cannot be issued for residential property and requires title insurer approval. Charge for this is $250. So this is a very limited endorsement that protects against usury laws, and you may not see this one too much. Variable rate endorsement, they removed the fixed rate conversion endorsement. The standard variable rate endorsement and negative amortization endorsement have been rewritten to include alter versions, and these endorsements carry a charge of $50. There's no particular substantive change except that the fixed rate conversion has been eliminated. The language itself in these endorsements is pretty similar to what was there before. Waiver of arbitration just was amended to reference 3 numbered arbitration conditions in the 2021 forums. They were kind of pointing in the wrong direction to the wrong clause, and now they specifically refer to the clause that has to do with arbitration. Z is the last letter in the alphabet and our last slide. The zoning endorsement insures against loss or damage in the event the land is not classified as in the zone stated in the endorsement and that the uses specified in the endorsement are not permitted. If you're going to issue this endorsement, you need a zoning search. If you're not going to get a letter from the municipality as to the zoning and the zoning uses, you get a zoning search from your municipal carrier and you fill in the blanks exactly what's on that zoning search. It is a classification R1 and you can use it for 1, 2, and 3 families. All that has to be filled in. 1A fills in the zoning classification and 1B adds the permissible uses. So you cannot use this one, and when we get to our underwriting procedures, you're going to see if you're going to issue this, you must get a zoning search. That is the end of our presentation as it is. Vince and I are available for questions. We're going to do a question and answer seminar next week for any lingering questions that you have after these presentations. If you have any questions now, you can ask them. Otherwise, we can wrap this up. Vince, do you have anything further to say on any of this material?
No, I think you did a great job. Just think of your questions. Try to take a look through the manual. If this is the first time you've had an opportunity to actually look at the manual, take a look around. And your eyes are not deceiving you. Things are not in order. If you look in the actual exhibits, you'll see that the endorsements are kind of scattered all over the place. That doesn't mean they don't have anything to do with each other. Just it was basically the manual was adopted to inherit the current structure, and as a result, you're going to see some of these things look like they're just kind of bolted on.
Right, it could be confusing. That's why we're going to have this question and answer. It's a lot to absorb, and we're going to be sending out a memo. We're going to help you figure out where your old affirmative insurance was, now is in a new endorsement. As I mentioned in the last class, you're going to rip out every single piece of affirmative insurance that you've ever added into your title reports. They shouldn't be there. They should never be there. They should never be automatic. They should only be given when requested and when brought through an underwriting counsel. What the new suite of endorsements does is take away all that underwriting. It makes it all uniform so that everyone's giving the same coverage. Make sure that you do not get intimidated by lenders' counsels or now purchasers' counsels, because now there are owners' things, into giving something that's not in the endorsement itself. You have the absolute ironclad power to say, it's not in the rate manual, I can't give it anymore. You're going to have this buy this endorsement, buy that endorsement in order to receive any type of affirmative coverage. Okay. And if there's nothing else, then I think we're going to wrap up this session. Drew, are there any questions?
Yeah, hey, Catherine. There was a question that came in for survey endorsement. Usually we used it for refinance and not need to order the survey, but I believe you need to fill in the survey information. Does that mean that we have to order a survey for a refinance now?
Well, the survey endorsement has been gone a long time in New York. I know it still remains in other states. But if you have a commercial property and the lender wants an Alta 9.X, you will have to get a survey. A lot of these encroachments, covenants and restrictions, any of these matters, you're going to need a survey. In some cases, and it's been bandied about a lot, is that you may need an Alta survey, which is like a super survey. It shows everything that you need and you can see what it is. Also, when you're doing these, when you're doing your survey readings anyway, you compare the survey with the description, you compare the survey with the tax map, you compare the survey with the file map. I don't know if everyone's doing this, but you compare the survey with the covenants and restrictions. I was reading a survey the other day and it had a setback line violation. I raised it. That is what your job is when you're doing the survey, is to put in these exceptions saying, we'll cover you in Alta 9.X or Alta 28.X, except this that we found, that the setback line has been violated, that you're running an abortion clinic on a church property, whatever it is, it's whatever violation you see, and you must read all your CNRs and your easements, you have to accept that in the policy, and then you can give the Alta 9. That is the reason for the survey, because your surveyor should be putting on the driveway easements and the water easements and whatever affects the property and runs across the property. So you will absolutely need a survey for those circumstances. And if it's a residential refinance and they're asking for these, oh, well, we need a survey. It can be, as we've done, an older survey with an inspection, but we still need to be able to carve out from the coverage we're giving any exceptions. And the only way we can do that is to see what's actually on the land.
And Catherine, I would just add that to the extent the question was referring to the two new Alta survey endorsement, same as survey endorsement or same as portion of survey endorsement, yes, and you would certainly need a survey if you were issuing those two endorsements.
Yes, absolutely. Any other questions?
No other questions.
Okay,
Oh, wait, sorry. More came in. So the person that asked that first question, it says it's for residential. Understand that commercial would need survey, but for refinance, usually the title owner won't be able to find the survey. So we give survey endorsement attached to the loan policy to the bank.
I think there might be a little confusion here. That there is no survey endorsement, as Catherine was referring to it now, as a separate thing. Several years ago, I think it might have been 2006 or thereabout, but the survey endorsement coverage was rolled into the jacket of the title policy. So there was no longer a need to include a separate survey endorsement. What you're seeing here in the manual is really just kind of the adoption of Alta's version of the same as survey endorsement that has already been in the manual. Those are distinct things. So it's important not to confuse those two things. Whenever you're issuing an endorsement guaranteeing that the land is the same as a particular survey, you need a particular survey to assert it. So you need an endorsement. You need a survey. And if for instance, let's say that the survey, the request is I want a survey. I want a same as survey endorsement that specifies the land is the same as a survey conducted in, let's say, 2006 or something like that. Well, I would want not just the survey from 2006, of course, but I would want a current survey. I want to make sure this land is still the same as was described in that previous survey. But again, this is a distinct issue from the survey endorsement that you're talking about that goes to a lender.
One more response here, but if we have to fill in the survey information on the survey endorsement, then it defeats the purpose of not ordering survey for a residential refinance.
But it's not necessarily going to be ordered.
Right. It's only if the lender is requesting a land same as survey endorsement. There is no survey endorsement. If they're requesting a land same as survey endorsement, if they're requesting Alta 9, then you need a survey. You know, that's the bottom line. That's the underwriting of it. This is the reason behind it. If they're not requesting, say they're just doing the waiver in the 8.1 and the residential, then you're not ordering a survey and you're not giving these endorsements, and it really doesn't matter.
Right.
If you want to speak about this more online, you know, our information is right there. You can always email us or call us, and we can go over the situation a little more. But we're not requiring you to order a survey on every refinance. It's just when they ask for specific endorsements that require a survey in order to insure, that's when you have to actually order the survey.
I think that's, if anyone has any questions that they need answered immediately now, send them in. Here we go. Which endorsement would be used if a lender is looking for insurance on variations, i.e. fences varies from record lines?
We're going to get into that a little more. We're going to try to make you a guide, like a quick guide as to say, okay, if we usually give for fence variations, this is where you look, you know, just because it is a little confusing with all of these. I don't have it exactly in front of me right now.
Well, I think it could also depend on the situation, you know. What are we talking about is varying? Are we talking about a fence? Are we talking about a building? Are we talking about trees? You know, there's a menu here that each offer different things that may or may not be what the insured is looking for. And so I think for right now, I think we would have to look, I think what you'd want to do is you'd want to look at the different types of the 28, 35, 36, and 9 series that most clearly address the issue that you're talking about.
Right, like you have the 9 series each endorsement has their own definition of improvements. Like the 9.3-06, puts in lawn, shrubbery, trees. Each of them does something a little different. And fence is going to be covered by, one of these policies. But like I said, we're still working on what goes where. But it's probably going to be something like the 9.3-06.
And also, I think one of maybe the ancillary benefits of this new filing and the providing all these guardrails for affirmative insurance, there could also be some renewed appreciation for some of what's already been out there, like the residential mortgage endorsement, which actually provides a good deal of affirmative insurance on its own. And I'm sure we can all appreciate that a lot of times the affirmative insurance that we've actually been asked to provide is like, providing, sand in the desert. They never really need it in the first place. So.
Yeah, that is the truth. Lenders, attorneys tend to have a checklist and said, I want this. And we said, but you don't have that. I want an Alta 9 for covenants and restrictions, but we didn't find any covenants and restrictions. How could we possibly give this to you? So, you still have to watch with them and, yeah, exactly. Let's not go into that. But, you have to watch and you have to push back and you have to, say we have our marching orders. We can't give you what you're used to. We'll give you what you're used to in other states now that we have it in New York, but we're not going to give you anything that you say, oh, this is the language I want. Because anyone who knows me, I send back their language red line, saying, I'm not giving this, I'm not giving that. You can give this, this is limited. A lot of the affirmative insurance out there is terrible, and that's why I'm absolutely thrilled that we have no longer any free form and it has to be found somewhere. We're going to help you find it. We're going to help ourselves find it. It's a lot to absorb, and we'll all figure it out together. But we will have certain things in the next. They may not all be ready in time for October 1st, but like I said, we're going to see if we can find you, make you a cheat sheet. There's going to be a memo. We're working on an endorsement guide that you could, keep on your desk and flip through to see, when you need these things and what the underwriting requirements may be. With the underwriting itself, if it requires approval, we're making this guide so you can say, okay, I have A, B, C, and D. Now I can give it to my underwriter, and now they can approve it because they see that I have everything that I need. So that's the way we're hoping it's going to work is, you're looking through this, you're seeing what you need, and you're presenting it to us complete, and we're saying, okay, go. Here, take the endorsement. It's good. So it's a lot to do, but, we're working very hard on this, and, if you have any questions, you can always reach out.
Great. Do you have a timeline on the guide is a question.
It's one of those, takes 10% of the time to do 90% of the work and 90% of the time to do 10% of the work. That's kind of where we are right now. So, I mean, we're hoping for October 1st, but, we're 10 days away, and, we'd have to ignore all your underwriting questions in order to finish all this, but we're going to try as much as we can. Our memo will probably our initial memo will probably give you highlights on the main ones that you'll probably need right away. And then we'll go with the deeper guide as we can.
Well, Catherine, is it okay to ask for any specific pieces be in this guide, or do you want to just take care of the topics yourself? Wasn't sure if any immediate feedback would be valuable on this guide.
I'm not exactly sure what you mean on that.
Or any top requests for items that should be in the first version of the guide as opposed to the more fleshed out version.
I mean, we're going to concentrate on the ones that'll be more more issuable by our agents, given their transaction makeup of their business. But we're hoping we will have a guide for all the endorsements when we're done.
And as Catherine has definitely made plain, we're obviously aware that the subject of affirmative insurance is really core to this. And so, we're going to obviously be addressing, as one of our first orders of business, how the TIRSA 9 is being substituted. What is being substituted for the TIRSA 9? Because that's really the endorsement that provides everything that we can do today is really found in the TIRSA 9, and now it's kind of broken into these little component endorsements. So we're certainly going to include that, and we know that a lot of your questions are going to be relating to
All right. Well, any parting thoughts, Catherine or Vince?
Nope, we're all in this together.
Great. Well, thanks everyone for sticking around. Very valuable information, despite it being rules and regulations and updates. Hope you're all a bit more informed after the last hour and 56 minutes here. I'm going to be uploading a recording of this to our YouTube page and our website. I will include timestamps in the description section of that. It will be definitely sent out in the reminder email for the Q&A session next week. If anyone would like it sooner than that, just send us a note. I'll make sure you get the link. So same time next week, and get your questions ready. We'll be ready for them. Thank you.
Thank you. And just, thank you. And just remember, you do have a copy of the manual now. You cannot use it until October 1st, but you can use it to review what we've gone over the past two sessions and craft your questions for next week.